The Laundering, Case 07, the Oversight Cycle. How procedural inquiry retires the question it was created to ask. Open the case.
For 30 years, Canada has responded to credible allegations of war crimes by its military with civilian inquiries whose mandates are narrower than the question being asked. Each inquiry has been obstructed by the government that called it, has cleared the small set of named individuals it was authorized to examine, and has filed a report that enters the public record as the country's accountability response to a question the inquiry was structurally prevented from answering.
And the connection to Case 01.
Case 07 is the second in the series to examine a closed legitimacy circuit. Case 01 documented the architecture as it operates between universities and municipal police. Case 07 documents the same architecture between civilian oversight bodies and the Canadian Armed Forces. The vocabulary of placement, layering, integration carries over unchanged. The question of whether Canadian soldiers transferred detainees to torture in Afghanistan, like the question of whether they tortured a Somali teenager to death in 1993, has now been processed by 2 formal inquiries and 1 refused inquiry. It has not been answered by any of them. That is not a failure of the inquiries. That is what the inquiries are for.
Frame. The inquiry is the mechanism, not the failure of accountability, the form of it. Start with Somalia.
In March 1993, Canadian soldiers of the now disbanded Airborne Regiment beat to death a Somali teenager named Shidane Arone. The killing was photographed by the soldiers responsible. Other abuses occurred during the same deployment. The Canadian public was, briefly, shocked. A commission of inquiry under Federal Court Justice Gilles Letourneau was constituted in 1995 to investigate. In December 1996, before the commission had reached the events in Somalia themselves, Prime Minister Jean Chrétien ordered the hearings shut down and a report produced within a year, on the stated grounds that Canadians had lost interest. The 5-volume final report appeared in summer 1997. It was, by its own description, an incomplete accounting. The Commission had never examined top-level governmental decision-making. It had never investigated the actual atrocities.
And the Afghanistan cycle.
In November 2009, a senior Canadian diplomat named Richard Colden testified before a parliamentary committee that detainees captured by Canadian forces in Kandahar and transferred to Afghan custody had been tortured as a matter of standard operating procedure. He testified that he had sent warnings to Ottawa beginning in 2006 and 2007. He testified that the warnings had been ignored, his reporting suppressed, and his credibility attacked. On January 1, 2010, Prime Minister Stephen Harper prorogued Parliament, ending the committee's hearings.
And the MPCC.
A separate inquiry, the Military Police Complaints Commission's public interest hearing on the Afghanistan file, had already been constituted on a complaint by Amnesty International Canada and the British Columbia Civil Liberties Association. Its mandate was to determine whether 8 named members of the Canadian Forces Military Police had failed in their duty to investigate the transfer of detainees to a risk of torture. The Military Police Complaints Commission, like the Somalia inquiry before it, was systematically obstructed by the government that had constituted it. Approximately 4,000 of an estimated 40,000 relevant documents were ever disclosed. The final report was released on June 27, 2012. It cleared the 8 officers. It did not address whether Canada had transferred detainees to torture.
And the refused inquiry.
As an opposition member of Parliament in 2009, Justin Trudeau supported calls for a full public inquiry into the detainee question. As Prime Minister after 2015, his Minister of National Defence, Harjit Sajjan, declined to call one, on the stated grounds that detainees had been, quote, treated humanely, end quote.
And the architecture.
This is the architecture under examination. It is not a story of any single failed inquiry. It is a story of the formal procedure by which Canada metabolizes credible allegations of war crimes by its military. The procedure has been demonstrated with consistent results across 3 federal governments of 2 political parties over 30 years. The inquiry is not what failed, the inquiry is what worked. It produced, on schedule, the document that allows the political and military institutions named in it to resume operating with their reputations procedurally intact.
Cycles. 3 decades, 3 cycles, the same architecture.
The Regina Police Service has commissioned 8 cycles of its perception survey since 2011. The Government of Canada has, in the same window of analytical attention, processed 3 cycles of its accountability response to allegations of war crimes by Canadian forces. The pattern across the 3 is structurally identical. Each cycle terminates with a document that does not address the substantive question.
Cycle 1.
1995 to 1997. The Commission of Inquiry into the Deployment of Canadian Forces to Somalia, the Letourneau Commission. Liberal majority government under Jean Chrétien. Shut down by order in Council on January 10, 1997, before the Commission had examined the atrocities themselves or reached top-level governmental decision-making. The Commission documented forged documents, evasive witnesses, and outright lies in its final report. Outcome: incomplete report, no criminal charges at command level, the Canadian Airborne Regiment disbanded, airborne reputation destroyed, institutional question of complicity not adjudicated.
Cycle 2.
2008 to 2012. The Military Police Complaints Commission, Afghanistan Public Interest Hearing. Conservative minority government under Stephen Harper. Document disclosure effectively ceased between March 2008 and November 2009. Parliament prorogued on January 1, 2010, specifically to end concurrent committee testimony. The Commission's final report cleared the 8 named officers and devoted an entire chapter to government obstruction of the inquiry. Outcome: 8 officers cleared, 4 procedural recommendations, roughly 4,000 of 40,000 documents disclosed, substantive question of transfer to torture not adjudicated.
Cycle 3.
2015 to present. Refused public inquiry under Trudeau, Sajjan determination of humane treatment, 2016. Liberal majority government under Justin Trudeau, who had supported calls for an inquiry as an opposition member of Parliament in 2009. Defence Minister Harjit Sajjan determined in 2016 that no public inquiry was necessary because detainees had been treated humanely. The 2016 open letter from Amnesty International Canada and the British Columbia Civil Liberties Association calling for an inquiry produced no government response. Outcome: no inquiry, no accountability process, and as of 2024, Colvin has alleged additional disappearances of hundreds of detainees under an undeclared program.
And across 3 cycles in 2 parties.
The question has been placed with 3 different bodies: a Royal Commission, a Statutory Complaints Commission, and a Parliamentary Committee, and answered by none of them. Each cycle has terminated with a record that says, in effect, this body was not the right body to answer this question. The next body, by design, has been even narrower.
Actors. The institutions and the named individuals. Walk the five.
As Case 01 anchored 5 Regina institutions, this case anchors 5 institutional roles. Names belong to the public record. First, the commissioning body, the Military Police Complaints Commission. Federal, established 1999 under the National Defence Act, statutory civilian oversight body for the conduct of Canadian Forces military police members. Constituted with subpoena power for documents and witnesses, but with limited recourse when the government invokes national security to withhold disclosure. Chair at the time of Constitution, Peter Tinsley. Chair at the time of the final report, Glenn Stannard. Co-author of the final report, Roy Berlin-Kett. Tinsley stepped down before the report was released. Second, the subject of inquiry. The Canadian Forces Military Police, 8 named members. Task Force Afghanistan, 2006 to 2007 deployments. The 8 individual military police members whose conduct was the formal subject of the hearing. The Commission's mandate covered their actions only, not the orders given to them, not the information environment around them, not the chain of command above them. The narrowing of the subject to these 8 individuals is the first analytical move that produces the laundering effect. The question is reformulated as one about line-level conduct rather than institutional policy. Third, the obstructing party, the Government of Canada, the Department of National Defence, the Department of Justice. Conservative Government, 2006 to 2015. National Security Disclosure Regime. The government that constituted the inquiry was also the party with custody of the documentary record the inquiry required to function. The Commission documented that between March 2008 and November 2009, the period of its public interest hearings, no new documents were received from the government despite repeated requests. Government invoked Section 38 of the Canada Evidence Act and related national security provisions to withhold disclosure. Fourth, attempted disclosure, Richard Colvin. Foreign Service Officer, Senior Diplomat, Kandahar, 2006 to 2007, Kabul, 2007. In November 2009, summoned by the House of Commons Special Committee on the Canadian Mission in Afghanistan and legally compelled to speak the truth, Colvin testified that the likelihood was that all the Afghans transferred by Canadians had been tortured, that this had been standard operating procedure for Afghan interrogators in Kandahar, and that his reporting to Ottawa from 2006 onward had been suppressed. The government invoked a national security order specifically in response to his cooperation with the Commission. His legal fees were cut off in November 2009 after his parliamentary testimony. Fifth, the complainants, Amnesty International Canada and the British Columbia Civil Liberties Association. Original complainants, February 2007, continuing advocacy. After the final report cleared the 8 officers and the Trudeau government declined an inquiry, they filed a joint open letter in June 2016 calling on the Prime Minister to launch a full public inquiry. No government response was forthcoming. They remain the institutional memory of the file outside government, and the principal civil society parties calling for adjudication of the substantive question.
Architecture, placement, layering, integration. The Case 01 vocabulary applied to a different substrate.
Case 01 borrowed the structural vocabulary of money laundering, placement, layering, integration, to describe how a closed circuit produces a reputational asset on a 24-month cycle in Regina. The mechanism is structurally identical here on a 30-year cycle at federal scale, with the substrate shifted from university credentialing to civilian oversight. The three-stage architecture is not metaphorical. It describes what the inquiry does step by step. Placement. A question larger than the body. The substantive question, did Canada transfer detainees to torture in violation of the Convention Against Torture and the Geneva Conventions, is placed with a statutory oversight body whose mandate does not extend to the question. The Commission's authority covers the conduct of military police members. It does not cover commanders, ministers, or the political chain of command. The placement is the first laundering step. The question now lives inside an institutional process whose terminus is, by statute, the conduct of 8 named individuals. Layering. Mandate, classification, delay. The narrow mandate is layered by national security disclosure exemptions, classification disputes, parallel parliamentary processes, prorogation, and 4 years of procedural attrition. The government, holding the documentary record, releases roughly 10% of relevant documents. Witness access is conditional on government cooperation. The question becomes structurally awkward to ask, not because anyone refuses to answer it, but because no individual body has the standing, mandate, and access to do so simultaneously. Integration. Report enters the public record. The Commission's final report is released on June 27, 2012. It clears the 8 officers. It makes 4 procedural recommendations. The government acknowledges receipt. Subsequent governments cite the report as Canada's accountability response on the file. The substantive question, having been placed with a body that could not answer it, layered through years of obstruction, and resolved in a report that explicitly disclaims authority over it, is now treated as adjudicated. The reputational asset is clean. The cycle repeats every 12 to 15 years. And the meta-observation. Somalia, 1997. Afghan detainees, 2012. Refused inquiry, 2016. The Royal Commission. The Statutory Complaints Commission. The Parliamentary Committee. The Refused Inquiry. Each is, in isolation, a defensible institution serving a real purpose. Their convergence on the same substantive question over 30 years, with the same null result on the substance, is the structural object under examination. The Commission Chair, writing in 2012, observed that, quote, "It seemed that some of the key lessons from the Somalia experience had not been learned," end quote. He was registering a procedural similarity between his own hearings and the Somalia hearings of 15 years earlier. The procedural similarity is the finding, but it is not the deepest finding. The deepest finding is that the Commission could observe the similarity, document it in print, and still produce a report that did not address the substantive question. The lesson of Somalia that had not been learned was not the government's. It was the inquiries, that the architecture in which it operates is one whose intended product is exactly the document the Commission was about to deliver.
Negative space. What the inquiry was not for. The 1,037 detainees, the chain of command, the political authorization. A reasonable reader, encountering the Commission's 2012 report for the first time, would be forgiven for assuming that Canada's transfer practices in Afghanistan had been formally examined. They had not. What the inquiry examined was whether 8 individual military police members had failed in their duty to investigate. The following matters, each of which has continued to attract civil society attention and journalistic scrutiny in the years since,
were outside the scope of the Commission, the Special Committee on the Canadian Mission in Afghanistan, and every other Canadian body authorized to look at this file.
Beyond the mandate.
Whether Canadian forces should have transferred any detainees at all, given the documented risk environment in Afghan custody from 2006 onward. The question that consumed the minority parliament of 2008 to 2011 and that prorogation ended. Whether senior commanders, including former Chief of the Defence Staff Rick Hillier, knew what Colvin's reporting had described. A question Hillier publicly disputed when testifying that Colvin's claims were, quote, ludicrous, and that, quote, nothing could be further from the truth than the assertion that most detainees were unconnected to the insurgency. Whether the Minister of National Defence's office under Peter Mackay and the Minister of Foreign Affairs received Colvin's reports. Documents subsequently obtained through media inquiry indicated that some of Colvin's reports reached the Minister of Foreign Affairs office.
In the 2024 allegation.
Whether, as Colvin alleged to the Globe and Mail in December 2024, hundreds of additional detainees were captured and transferred under an undeclared detention program during the Kandahar mission, a claim made by a recently retired diplomat who held senior posts in Kandahar, Kabul, and Washington over 6 years, and which remains uninvestigated by any Canadian body as of this writing. Whether Canada complied with its obligations under the Convention Against Torture, the Geneva Conventions, and the International Covenant on Civil and Political Rights during the period in question. The substantive legal question that the Commission was not constituted to adjudicate and that no Canadian body has subsequently been constituted to adjudicate.
And what the case asserts and refuses to assert.
The negative space around the inquiry is larger than the inquiry itself. This is, again, not a failure of the inquiry. The Commission was a statutory complaints commission. It did exactly what its enabling legislation authorized it to do. The structural problem is not that the inquiry failed to answer the substantive question. The structural problem is that the existence of the inquiry and the production of its report has been treated by successive governments as if the substantive question had been answered. Nothing in this case asserts that the 8 named military police officers committed misconduct. The Commission's finding to the contrary stands. Nothing in this case asserts that any named individual lied. The structural argument requires only the observation that an inquiry constituted to examine 8 officers has, in the public political memory, come to stand for an examination of Canadian conduct in Afghanistan that never occurred.
Appendix. The Commission's report, navigable.
The Military Police Complaints Commission's June 2012 final report is the primary documentary anchor of this case. Like the survey methodology files in Case 01, it is a public document whose internal structure repays close reading. The appendix on this page is a navigable map of the report's 8 thematic branches, with grounded summaries and source citations attached to each.
Walk the branches.
1. The core subject, the transfer of detainees captured by Canadian forces in Afghanistan to Afghan authorities under a documented risk of torture. 2. The main actors, commissioners, complainants, military leadership, Department of National Defence, Government of Canada, Afghan authorities, and the NATO-ISAF context. 3. The key questions. Did the military police have a duty to investigate? What did they know? Was the information environment adequate? And were the governing arrangements sufficient cover? 4. The findings and themes. No misconduct by the 8 officers, serious findings on reporting, accountability, and information sharing, and an entire chapter on government obstruction.
And the rest.
5. The structural dynamics, military hierarchy, the limits of civilian oversight, national security versus transparency, and the recurring pattern across Somalia and Afghanistan inquiries. 6. Evidence and process, public interest hearings, witness testimony, classified information disputes, redactions, legal motions, procedural delays driven by government objections. 7. Outcomes and recommendations. 4 procedural recommendations on documentation, reporting, civilian oversight access to information, and clarification of military police responsibilities on deployment. 8. Broader implications. Trust in civilian oversight of the military, limits of statutorily constrained inquiry bodies, the role of national security claims, and Canada's international human rights obligations.
Close. What this case is and isn't.
This is not an accusation against any individual who served on the Military Police Complaints Commission, the Special Committee on Afghanistan, the Letourneau Commission, or any office of the Government of Canada. The commissioners of the Commission documented the obstruction they faced and published it. They issued findings within their statutory authority. The complainants, Amnesty International Canada and the British Columbia Civil Liberties Association, used the only forum available to them. Richard Colvin, by every public indication, did exactly what a senior diplomat is supposed to do when his reporting describes a violation of international law, and was punished for it. There is no shortage of individual integrity in this story.
And the structural argument.
The argument, as in Case 01, is structural. An oversight architecture in which the body authorized to ask a question of the military is not the body with the mandate to answer the question. In which the documentary record required to answer the question is controlled by the institution being examined. In which the parliamentary process that could compel answers can be ended by prorogation. In which the government that calls an inquiry is the same government that obstructs its disclosure and the same government that decides whether to act on its recommendations. That architecture, regardless of who staffs it, will reliably produce reports of the kind the Commission produced in 2012. 3 cycles in 30 years is sufficient to call it a function of the architecture rather than a failure of any cycle.
And the close.
The Regina case in Case 01 ends with the observation that the apparatus runs and that the next cycle is being designed. The same observation closes this case. Canada has been militarily engaged abroad continuously since 2001. The conditions under which the next allegations of war crimes by Canadian forces will be made are not hypothetical. The architecture that will process those allegations is the architecture under examination here. It is the same architecture that processed Somalia in 1996 and Afghanistan in 2012, and refused to process either question in 2016. It is in working order.
2 true statements.
Canada's armed forces train in Petawawa, Edmonton, Valcartier, Gagetown. The civilian oversight body that processed their last alleged war crimes operates in Ottawa. The next cycle begins when the next allegation is made. Both statements are true. Their relationship is the story.